Let us pray. Eternal God, we thank you for the generosity of your blessings given to us, particularly for the blessing of freedom. This freedom has been given by you and defended by the gallant acts of many men and women throughout the centuries. And we know that freedom is given and protected not for our own personal advancement, but to allow us to love and serve others. Help all of us as citizens of Minnesota to use this gift of freedom for the true good of all people, thinking of others before ourselves. God, please send your blessing upon the members of this assembly as they proceed to serve the people of Minnesota in truth and love. May the virtues of temperance, justice, fortitude, and prudence grow in all their hearts and in the lives of all the residents of Minnesota. May your abundance of grace guide these elected officials in all of their decision-making. May your care bring them hope in moments of despair, courage in times of fear, consolation in occasions of discouragement, and joy in their service. May God bless all the members of this House of Representatives, the members of our Senate, our governor, and all of our elected officials, and in particular on this day, send your blessing upon Representative Woodard. May God also bless all the citizens of Minnesota and the United States of America. Amen.
Amen. The chaplain for today is Father Nels Jindal from St. Thomas Academy, St. Paul, Minnesota, and a good friend of the Woodard family. Pledge of Allegiance. Please remain standing to recite the Pledge of Allegiance to the flag of the United States of America. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. The clerk will take the roll. The clerk will close the roll. A quorum is present. The clerk will read the journal of the preceding day.
Journal of the House, 88th Session, 2014, 95th day, St. Paul, Minnesota, Thursday, May 1st, 2014.
There is no objection for the reading of the roll will be dispensed with, and the journal will be approved as corrected by the chief clerk. Hearing no objection, the journal is approved as corrected by the chief clerk. Introduction of bills. The following House files have been offered for introduction today, and the chief clerk will report the House files and give them their first reading.
Introduction and first reading of House Files 3368 and 3369.
First reading, House Files 3368 and 3369.
Messages from the Senate.
Messages from the Senate, Mr. Speaker, are hereby announced to passage by the Senate of the following Senate files herewith transmitted. Senate files numbers 511 and 2614, signed Joanne M. Zoff, Secretary of the Senate.
First reading of Senate files.
Introduction and first reading of Senate File 511, an act relating to health. Schoen moves that Senate File 511 and House File 435, now on the General Register, be referred to the Chief Clerk for comparison.
Hearing no objection, so ordered.
Introduction and first reading of Senate File 2614, an act relating to transportation. Mason moves that Senate File 2614, House File 3038, now on the General Register, be referred to the Chief Clerk for comparison.
Hearing no objection, so ordered. Calendar for the day. The first bill on the calendar for the day is Senate File 2466. The clerk will report the bill.
Senate File 2466, an act relating to public safety, the second engrossment.
The member from Dakota, Representative Atkins.
Thank you, Madam Speaker. Just a point of parliamentary inquiry, if I might.
State your point of parliamentary inquiry.
I believe that we have made a motion to amend the substitute the House language. I just wanted to make sure that that's before the body.
There's an amendment at the desk. The clerk will report the amendment.
Atkins moving to amend Senate File 2466, the second engrossment as follows. Delete everything after the enacting clause and insert the language of House File 2288, the third engrossment. The amendment is coded DEA 2288.
Representative Atkins.
Thank you, Madam Speaker. Members, the amendment before us simply puts the language in the way that it passed the House. So we're substituting the House language. And Madam Speaker, it might be best, at least it'd be my preference, if we take up that amendment now and pass that amendment so that we can move forward with the House language.
Any discussion to the amendment? Hearing none, all those in favor, please say aye. Those opposed, please say no. The motion prevails. The amendment is adopted. Representative Atkins.
Thank you, Madam Speaker. If you want to shock your constituents, tell them this, that in Minnesota, under current law today, the government can use cell phone tracking data, their own cell phone tracking data on their cell phone to establish their whereabouts, to know where they're at any given time without getting a search warrant, without giving them notice, and without probable cause. I actually tested that statement on a few of my constituents. They were absolutely blown away that the government right now under current Minnesota law can track you using your cell phone without establishing probable cause, without a search warrant, without even giving you notice that it's occurring. Current law was written 25 years ago, before these sorts of devices that most of you carry, many Minnesotans carry, before these sorts of devices even existed. 25 years ago when it was updated, it was for things like wiretaps and for access to emails, but that was long before things like cell phones and smartphones even existed. So people are shocked when they hear that. Why should we care? Well, because when you talk about tracking someone's cell phone, it can tell a lot about who you are, who you associate with, who your physician is, where you go to church or synagogue or mosque. It can tell whether or not who your friends are. It can tell whether you go to a family counselor or whether you have a defense lawyer. That's what can be established by simply looking at your cell phone tracking data. So we set out to strike a balance between allowing law enforcement, the government, law enforcement to do solid investigations using new technology, things like Kingfish and Stingray and other marine labeled devices that allow them to track your cell phone location, and allows law enforcement to do terrific investigatory work to try to track down criminals, or better yet, prevent crimes. At the same time, though, we also wanted to make sure that we were protecting people's privacy for those very reasons that I described before, because a lot can be told about an individual just based on where they travel and where they take their cell phone, which is with people most of the time, at least almost on a 24/7 basis. So we've established a bill today that struck that fine balance, Law enforcement supports it. I believe there's a handout that's coming to your desks that talks about the support from the law enforcement community for this bill. But it also is supported in large part by privacy advocates. Is it perfect as far as privacy advocates are concerned? No, because it doesn't yet go far enough. But it goes a long way and miles beyond where we are under current Minnesota law. It does three things in that respect. First, it requires that probable cause be established. Right now, under current Minnesota law, all you have to do is say that it might be related to an investigation. It might be relevant to an investigation. This would require that the law enforcement community go before a judge and establish that, in fact, there is probable cause to establish that a crime has been committed. That's a big deal. That's a high standard. The second thing that it does is it requires notice. Under current Minnesota law, there is no notice to the person being tracked. This proposal, this legislation before you, would require that the person being tracked get notice. Now, that notice would come after the investigation is concluded. Again, the judge would have input in terms of when that notice occurs, but it would occur. You would find out that, in fact, you were being tracked. And finally, and one of the frustrating things that's being addressed here is that under current law, we really don't know how often these devices are used. How often this new technology that allows government to track people's cell phones, Kingfish, Stingray, these sorts of technologies, we don't know how often it's occurring. We don't know really what the circumstances are. It's a very cloudy, murky sort of situation. Go ahead.
Members, if you could keep your conversations off the House floor. Some members are having a hard time hearing the debate. Please take your conversations in the retiring room or the alcoves. Representative Atkins.
Thank you, Madam Speaker. And shoot, it's a Friday. People we get a little chatty on Fridays. But the final thing that it does is it provides for a report, so that each time one of these orders is granted by a judge, it would be shared with the courts, and eventually on an every other year basis, November of each year, every other year, we would get a report here at the legislature to report on how often these sorts of orders are being granted and the circumstances under which they're being granted. That's what the bill does, Madam Speaker. I believe there's an amendment that you're probably likely to take up next, but I just wanted to urge members' support and would be happy to stand for any questions.
There's an amendment at the desk. The clerk will report the amendment.
Moving to amend Senate File 2466 as amended. As follows, the amendment is coded A5.
The member from Ramsey, Representative Lesh.
Thank you, Madam Speaker. Members, this amendment is the product of several years of discussions about what Representative Atkins just told you about, all the things that we don't know about how this technology is being used, the effects on you and on your family. Representative Atkins' bill is an effort to ensure that you aren't tracked from place to place without your knowledge if there's no independent probable cause for it, and sets in some good parameters for law enforcement to ensure that those rules are adhered to. The rules that we set here for the state of Minnesota. It's been really difficult to find out these facts. And the small tip of the iceberg of what we know is dwarfed by all the facts that we don't know. And that mostly has resulted from the fact of a reluctance, an understandable reluctance, of the subject holders of this data to come forward and to testify about how they use this to track Minnesota citizens and how long they hang on to the data and what their intent is for that data. Their reasons for their reluctance are, like I said, are perfectly understandable. I've been told by one law enforcement official that relationships with the FBI, with the ATF, with the manufacturer would be ruined. Relationships with other local law enforcement agencies would be ruined if, in fact, that law enforcement official had to come forward on the record in public and say all the nuanced details of how they use this technology in order to track the daily lives of citizens. And frankly, it makes sense to me. I get that. But the fact remains that we have an obligation when we set the rules here in the state of Minnesota to know how it's being used, and to know that, in fact, the way that it's being used comports with the laws that we've set and the limits of the Constitution of the state of Minnesota and the United States. So because of that, and because of a failure to have an effective open hearing on that in January, I thought the appropriate thing to do would be to set up a separate commission. This commission would not be subject to the typical rules, committee rules, the open meeting laws that normally are sacrosanct here in the state of Minnesota, and for good reason. There should be very, very few reasons that we accept any of our procedures from the open meeting law and the dictates of how we run business around here. But if there are any reasons, this is one of them. Because the consequences of this legislature not proceeding forward with adequate information of all this technology is drastic. And we've seen this time and time again for the past several interims. When we went home in 2012, soon after that, the Minneapolis Star-Tribune did a data practice request of the Minneapolis Police Department and was able to find 2 million records of license plates and locations of license plates around the city. They tracked the mayor, R.T. Ryback. They tracked other individuals in town. And the Star-Tribune was able to find this through a data practice request. And remember that the valid uses of this information was only 0.8%. The other 99.2% of these images were of innocent people. So in that context, we came back the next year and had to come up with rules in committee of how this technology could be used. And it didn't work. It got stalled all the way through session. It got stalled at the end of session. And we still don't have a legislative solution to that. And quite frankly, there has been a reluctance on the part of some individuals to talk about that technology. And again, like I said, I understand why. Then we went home last year in 2013. And immediately in the interim, we get the NSA leaks. And immediately thereafter, there's all this discussion in Minnesota about the usage of drones, as well as the use of cell phone tracking technology, which is only brought to light because of some of the NSA leaks. And questions were asked about the nature of some of the technology being used by law enforcement agencies in Minnesota. And so we started trying to have discussions about that. We still don't have a solution. This bill is one effort to forge a solution for just one technology. But at the beginning of session, some of you may remember that we tried to have a hearing on this. And the committee invited 25 policymakers from law enforcement agencies, the largest law enforcement agencies in the state. We wanted to leave the smaller ones alone because we imagined that there was a little likelihood that they had this technology and to use it. But only 5 came. And I'll admit I was a little frustrated at the time. But in retrospect, I completely understand why. And it reflects what was said to me by one law enforcement officer. He said, "You got to see it through my eyes. This is really tough for us to come forward and talk about how we use this in public." And I've seen this from folks in the military too. They're very, very concerned about operational security. And a lot of things that you would not normally think fall into the gamut of operational security do. Moms write to their kids over in Kuwait or Iraq and say, "Hey, where are you now?" And kid says, "Mom, I can't tell you." Mom says, "Come on, you got to be kidding me." Kid says, "No, this is very serious. Operational security is a very, very serious concept." It works the same way with law enforcement in the state of Minnesota. So in order to alleviate that, as well as to remove any other reason not to come forward and be completely forthcoming about the nature of that technology used, the solution would be a commission that is not subject to data privacy, which would have a subpoena power that normally requires a 2/3 vote in committees around here, thereby making it subject to political winds, and we don't want to do that. We want this to be non-political, and of course it would be if it's not out in the open in public. And so I would ask members support on this. The purpose for me putting forward this amendment today, members, frankly, is to have a robust discussion about the implications for it. So thank you, Madam Speaker.
There's an amendment to the amendment. The clerk will report the amendment.
Judge moving to amend the Lesh amendment to Senate File 2466 as amended as follows. The amendment is coded A7.
The member from Wabasha, Representative Driscowski.
Thank you, Madam Speaker. Thank you for your amendment, Representative Lesh. I have an amendment to the amendment here that would prescribe that the commissioners on this commission would need to serve without compensation for their services as commissioners, and that is included in the amendment to the amendment before you. I would encourage your support and do not ask for a roll call vote, Madam Speaker. Thank you.
Representative Lesh.
Members, I think this is a good, Madam Speaker, members, I think it's probably a good amendment. I urge you to vote yes.
Seeing no further discussion to the Driscowski amendment, all those in favor, please say aye. Aye. Those opposed, please say no. The motion prevails. The amendment to the amendment is adopted. On the amendment, the member from St. Louis, Representative Metsa.
Thank you, Madam Speaker, members, and thank you, Representative Lesh, for bringing this forward. I do think that it's time we get something together to start discussing these very important issues, and I would urge a green vote on this to move forward and create a committee that would be able to address them.
The member from Blue Earth, Representative Cornish.
Madam Speaker and members, I would encourage a no vote just from looking at the amendment procedurally. Representative Atkins, this enlarges the scope of this bill greatly. You're talking about forming a commission with subpoena power, legislative staff doing the work. You have a statement here will not be open to the public. Disclosure of not public data by a member of the commission is grounds for an ethics complaint. It just puts a whole new scope on your bill, Representative Atkins, and I have no problem with the bill, but then I would have to vote no if this goes on, and so I just encourage a no vote. Thank you.
The member from Dakota, Representative Atkins.
Thank you, Madam Speaker. Will the author of the amendment yield, please?
He will yield. Representative Atkins.
Thank you, Madam Speaker. Representative Lesh, I know you just offered this amendment recently. Have you had a chance at this point, let me frame it a little bit, at this point the bill has, as drafted, has support from the law enforcement community. Privacy advocates also support it. They still don't think it's gone quite far enough, but they think it's a dramatic improvement over current law. Have you had an opportunity yet to find out if law enforcement and the privacy advocacy community are also in support of your amendment?
Representative Lesh.
So, Madam Speaker and Representative Atkins, in the approximately dozen hearings that we've had on issues related specifically to your bill or drones or automatic license plate tracking or the various issues that we've had, this session on those topics, this has come up, this bill area has come up in most of those. The language itself has not been vetted with either law enforcement or with privacy advocates. And I know that most of the time around here, that's a precursor, if not just a nice thing to have, in order to get support for your bill or your amendment. But I would submit to you, members, when we are conducting our fundamental function of legislative oversight, that you want to be careful about how much buy-in that you get from those individuals you purport to oversee. So every time when I brought it up on 3 occasions when the members of the law enforcement community have been there, Representative Atkins, after an exhausting discussion about issues relating to either drones or cell phone surveillance or LPR, multiple times, and I've said, you know, we can't seem to get the information. I understand why. we may have to move to the U.S. Senate model of a Senate Intelligence Commission or committee in order to consider these things that you're nervous about talking about in public so that we can have the information. And they've all kind of looked at each other and nodded and said, well, yeah, I guess. Now the details, no, I haven't gotten buy-in. I probably would, in retrospect, have had more opportunities, talk about it more with them, but I would not be looking for an ultimate buy-in because they would be one of the groups who we would be looking to oversee.
Representative Atkins.
Thank you, Madam Speaker, and thank you, Representative Lesh, for the answer. I'll tell you, when I was a kid growing up in Groveland Park with actually several of your cousins, there was this stream that we would cross, and there was a plank that went across the stream, and it was sort of a wobbly plank. And as you walked across it, if you even leaned ever so slightly one way or the other, you fell off the plank and into the stream. My fear is that while I appreciate your concern, and you and I have had some significant discussions, and I think I understand your concern. My fear is that this causes this tightrope that I'm on. It's even thinner than a plank to possibly tip over one way or the other. And I don't believe that there's support yet for the amendment. I'd encourage you to keep talking with the law enforcement and the privacy advocates communities. But with that, I have strong reservations about the amendment, and I just can't support it. But Representative Lesh.
The member from Isanti, Representative Johnson.
Madam Chair, members. Might be one of the few times I agree with Representative Atkins. The overall concept of this amendment, I understand and I believe is needed. The law enforcement communities, one thing they dread is shows like CSI and all these TV shows on the television that shows how they solve all these crimes through surveillance and technological wonders with the computers and the DNA and fingerprinting. The real world, it doesn't work, but they expect it. It makes it very difficult for law enforcement. Law enforcement also has the other issue with the technologies that they do have is letting the information out. Law enforcement is always 2 to 3 steps behind the criminals in this world. Every time we law enforcement figures something out in a way to catch them, because we have to a lot of times have to reveal that information in court. These people are watching that and learning what we're using to catch them. And they change their ways. Law enforcement is always struggling, always 1 or 2 steps behind. When they do get some technology that is working and working well, they're very hesitant and very unlikely to share that information because it is so valuable. But we also need to oversee what they do with our laws and our data privacy issues that are very important. This amendment would allow that to happen, where we would have some oversight, learning what they're doing, making sure that what they're doing is legal and proper. I'm going to ask that Representative Lesh does pull this amendment, and I'd be more than willing to work with him in the interim, put things together, and put a bill together for next year to get through so we can do this so that everybody is protected properly. Thank you.
The member from Olmsted, Representative Liebling.
Thank you, Madam Speaker. And members, I think there's a lot of agreement on this floor around this issue, and I'm really glad to see that. Thank you, Representative Johnson. I think Representative Lesh did an excellent job in his committee of educating us about this issue. And I do agree with those who are saying that the amendment probably isn't ready for prime time, because there are a lot of really important elements here that need to be thoroughly vetted, in large part so that the populace can have confidence in our oversight and what we're doing. Not so that law enforcement would necessarily agree, because nobody thinks they need oversight, right? We all think we're just fine without anybody telling us what to do. But the reality is that we have a country with checks and balances, and that is the beauty of our system. And in particular, we know that law enforcement and those who would operate in secrecy also need oversight. when we have our military and our police forces, they're very important to our country, but we're supposed to have a system where there is civilian control. Ultimately, we are that civilian control, the elected representatives of the people, and we need to make sure that we carry out that responsibility. So I really rise to commend Representative Lesh for his work, to support him in concept, to emphasize to all of you that this is a really important issue. I hope everybody's paying attention. I hope that we will all continue to work on this issue and be willing to exercise the kind of oversight that we really need to exercise. And we've seen this in the news a lot. Citizens are very concerned about secret gathering of data, how that data is being used. And sure, there are reasons that data is being collected, and there are important reasons for which it may be needed. But a balance has to be struck, and we are the ones who have to exercise that oversight. So with that, I thank Representative Lesh. I also agree that we're not ready to move forward with this at this time.
Any further discussion? Representative Lesh.
Thank you, members, Madam Speaker and members. As I stated at the beginning, my intent in offering this was to have a discussion. I think there still needs to be discussion, but there's enough nervousness on my side of the aisle that a proposal as forward-reaching as this requires more committee discussion. I wanted to have that discussion in conference committee, but I don't think there's the support on the floor to make it happen. It's going to have to wait. But I would ask that people keep their eyes out in the interim for these issues that come up related to technology, due to technology that are impacting you and your constituents, and be ready to discuss this in hearings in the interim and take make some movement on it next year. And with that, I would withdraw my amendment, Madam Speaker.
Representative Lesh withdraws the amendment. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, Senate File 2466 as amended.
Third reading as amended. Any further discussion to the bill? Representative Atkins.
Thank you, Madam Speaker. Members, and I usually don't. If I sense that I've got support for a bill, I just keep my big mouth shut. But I'd be a little off if I didn't. This was a really difficult place to find agreement between the law enforcement community, privacy advocates, and others. And I just wanted to thank Representative Holberg and Scott, Representatives Paymar and Loeffler, the law enforcement community, Mr. Neumeister and Mr. Diebel, and others in the privacy community for their efforts to find this piece of, if not peace in the valley, at least we don't get thrown off the plank in the middle of the stream. So with that, I'd appreciate members' support.
The clerk will take the roll on the bill. The clerk will close the roll. There being 120 ayes and 0 nays, the bill is passed as amended and its title agreed to. The next bill on the calendar for the day is Senate File 874. The clerk will report the bill.
Senate File 874, the second engrossment, an act relating to criminal justice.
The member from Hennepin, Representative Allen.
Thank you, Madam Chair. Senate File 874 establishes the prerequisites of a conviction or its equivalent for drug-related crimes in criminal court before a person loses his or her property through forfeiture in civil court. And this bill is about due process, about the basic principle of due process that no one acquitted of a crime in criminal court should lose his or her property through forfeiture in civil proceedings. Under current law, we treat forfeiture in civil court two different ways. For DWI, prostitution, fleeing a peace officer, and other designated offenses, under current law, the law requires that a conviction from the criminal trial be introduced into evidence in the civil case. This requirement provides adequate due process. For drug-related crimes, there is no prerequisite of a conviction in criminal court. In these forfeiture cases in civil court, the burden of proof is on the property owner to show that the seized property, cash and vehicles usually, is not associated with the controlled substance. Nothing that happens in criminal court matters. This is contrary to the presumption of innocence. What this bill does is it makes the forfeiture laws consistent, and it makes the conviction in criminal court a prerequisite for drug-related forfeitures in civil court. This bill also provides that the court must schedule a hearing within 90 days after the conclusion of the criminal prosecution. This bill is a compromise bill. It's part of an agreement with Minnesota County Attorneys Association, acting on behalf of associations representing law enforcement. And what this bill does is it allows the introduction of an equivalent to a conviction, which includes an admission of guilt, getting a diversion or a stay of a criminal sentence, or agreeing to be an informant as part of a plea bargain. And I think it makes some sense. There's some good arguments for this. For example, a stay of conviction or a diversion. I mean, we don't want to deter those type of proceedings. We don't want to create an incentive for prosecutors to go after a conviction. And I'm going to talk a little bit about what this bill does not do. This bill does not change the way that law enforcement operates. This bill keeps the two-track system, one of criminal prosecution in criminal court and two civil forfeiture in civil court. The bill does not change the administrative process that prosecutors nearly always use in drug-related forfeitures. The administrative process is the presumed process, and this bill it's estimated to affect about 3% of forfeitures. Those that where the property owner converts drug-related forfeiture from the presumed administrative forfeiture, judicial forfeiture, by filing a lawsuit in civil court. So this bill addresses those cases. This bill does not change the work of police officers, sheriffs. The bill changes only the work of the prosecutors in the courtroom. And this bill does not change the distribution of forfeiture proceeds to supplement law enforcement's budgets. And this bill is agreed to by as I mentioned, the Minnesota County Attorneys Association, and is supported by the Institute of Justice, ACLU, Minnesota Criminal Defense Lawyers Association, and Second Chance Coalition. And I just want to give you an example of and why I strongly support this bill, why Second Chance supports it. In my district, there's a intersection that has a four-way stop sign, and oftentimes the police will sit there, and if somebody doesn't completely stop at the stoplight, they will oftentimes stop them and think about it. They consent to a search. The officer looks. It finds maybe this person has $1,000 in their purse or their backpack, or is going to Walmart to get a money order to pay their rent or pay their utility bills, and the officer says, "Well, this looks suspicious. I believe it's related. It may be related to a drug crime." So he seizes that property, and so that individual, many times that individual is never charged with a crime. So that individual then has to file a civil proceeding and prove that her property is innocent. And oftentimes, most forfeitures are $1,000 or less. And so you can imagine the attorney fees will probably exceed that in most cases, so most people just walk away from their property. So I want to take a moment before I forget to thank the co-authors. There are, I think, 30 co-authors, and on both sides of the aisle. And I especially want to thank Representative Hilstrom for helping to bring all the parties to the table as it went through Judiciary. And so at this time I'll stop and I can answer any questions. And I know there's others that would like to speak to this bill. Thank you, Madam Chair.
There are no amendments at the desk. The clerk will give the bill its third reading.
Third reading, Senate File 874.
Third reading. Discussion. The member from Scott, Representative Beard.
Thank you, Madam Speaker, and thank you, Representative Allen, for bringing this bill forward. One of the committees I've never served on a committee that's dealt with civil law or any of the judicial issues, but over the years I've grown to just detest our civil forfeiture processes in Minnesota. We still have the dual track. We still have people who can be exonerated of a crime, particularly in the DWI arena, and still lose their vehicles. It particularly financially ruins small people who do not make a lot of money and who stretch their budgets to the end. And the game the system plays with them is unconscionable. So I'm glad we've taken this small step. I know the forces that are arrayed against changing anything here are very strong and have, unfortunately, a financial interest in keeping the status quo. I'm sorry that's the case, but I'm grateful that at least we're taking this one small step to start to break down this civil forfeiture mess we have in the state of Minnesota and protect innocents and protect property members where it needs to be protected from government and from the government's police powers. Thank you, Representative. I'm happy to vote green on this bill, and perhaps when I'm gone we can make even more progress on this issue.
Further discussion. The member from Blue Earth, Representative Cornish.
Madam Speaker, members, I too support the bill, mostly because the parties have agreed to it, but I think it was a really erroneous description given, and you aren't seeing the other side of what actually happens when a seizure takes place. And it's not Miss Innocent Twinkie driving down the road and happens to have $1,000 laying on the seat and they grab it for financial purposes. And the legislature is the one that made this mess. The cops didn't. You gave it to them, and now it's up to you to fix it. But don't blame the cops for a tool you gave them to seize property when you don't give them enough other assistance in property. And I don't think they do it for financial gain. The whole purpose of making them hurt, the criminals, was to take the money that they deal in the crimes and the weapons, and that's what we're trying to do. So let's at least have a balance here and not make it look like the cops are out snatching everybody's money so they can buy more radars. It's ridiculous.
Further discussion to the bill. Representative Allen.
Thank you, Madam Chair. And again, this doesn't affect what law enforcement does. If you recall in 2010 that the legislature made changes to the forfeiture laws, and so what those laws did was it required the law enforcement to provide a receipt. It required reporting of forfeitures, and it also allowed claimants to go into conciliation court if the property is under $15,000 to retrieve to get their property back. So this is about the due process involved. It's not meant to be a judgment on law enforcement, because that is governed by other laws. And so in the reform in the future, we know that you can't deny that there is a aspect of this where there is profit. And so that's something that is the nature of it. And so we just want to make sure that there are adequate due process protections in place, and so that we can curb the potential for abuse in this area.
Seeing no further discussion, the clerk will take the roll on the bill. The clerk will close the roll. There being 120 ayes and 0 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is House File 2670. The clerk will report the bill.
House File 2670 on the calendar for today, an act related to occupations.
The member from Hennepin, Representative Dehn.
Thank you, Madam Chair and members. House File 2670 is a bill that's come regarding licensure provisions for architecture, the board that oversees architecture, engineering, land surveying, landscape architecture, geoscience, interior design, otherwise known as the AELS-LAGID board. It does a few things. It actually speaks to the issue of the use of the term professional engineer, which is something that was brought forward by the engineers. And it takes out some unneeded language that has been around for a while regarding degrees and accreditation that would cover. It reassigns 2 hours of continuing education to require that continuing education be dedicated to ethics. It increases the keeping of records for the licensee from 2 to 4 years. It adds no costs, and there are no added fees associated with it. It's a good bill, and I would ask for your support.
There are no amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File 2670.
Third reading. Discussion. Seeing no discussion, the clerk will take the roll on the bill. Members, please vote. The clerk will close the roll. There being 111 ayes and 8 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is House File 2995. The clerk will report the bill.
House File 2995, the first engrossment, an act relating to public safety.
The member from Hennepin, Representative Erhardt.
Thank you, Madam Speaker. There's an amendment somewhere around.
There's an amendment at the desk. The clerk will report the amendment.
Erhardt moving to amend House File 2995, the first engrossment, as follows. The amendment is coded A3.
Representative Erhardt.
Thank you, Madam Speaker. Essentially what this does is put into statute the way that the industry is practicing now, and what it does is say, well, we don't have to worry about signing everything because the electronic means is available. And so what this delete does, it clarifies that the towing report need not be signed by the reporting officer and the tow driver. This is a compromise reached. Representative Brian Johnson discovered that we needed to make some adjustments here, and we did that, and I think everybody is now satisfied, and I'd appreciate your vote yes on this bill as it is now amended.
Any discussion to the amendment? Seeing none, all those in favor of the amendment, please say aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File 2995, as amended.
Third reading as amended. Discussion to the bill. The member from Isanti, Representative Johnson.
Madam Chair, Representative Erhardt, I want to thank you for bringing this forward and doing that amendment. Members, what's going on now is electronic data. The law enforcement community has gone into a paperless world. They no longer handwrite tow sheets. They're done electronically on a computer in your squad car. And a lot of times these tow sheets are emailed to the towing company. it is not possible to sign them. This is still keeping the tow sheet requirement in place and making it so it's a paperless operation where the information is electronically stored with the reports, and the tow operators are getting the information they need so they get the right vehicle. And it's also protecting the liability of the law enforcement agency and the tow operator by having the information and the condition of the vehicle marked down. Members, please vote green on this bill.
Any further discussion to the bill? Seeing none, the clerk will take the roll on the bill. The clerk will close the roll. There being 119 ayes and 0 nays, the bill is passed as amended and its title agreed to. The next bill on the calendar for the day is House File 2386. The clerk will report the bill.
House File 2386, the first engrossment, an act relating to the judiciary.
The member from Ramsey, Representative Johnson.
Thank you, Madam Speaker. Members, this is the Board of Public Defense unsession bill. It does two things. Let me briefly just describe that. First, regarding petition filing and post-conviction relief, the bill removes the requirement that an original and 3 copies be filed by the petitioner, because this will become obsolete when the court fully implements their e-filing initiative, so efficiency in government. Secondly, regarding issuing orders of restitution, this bill removes the provision that allowed notice to offender's attorney as being noticed to the offender. And this is important because after sentencing, the folks that have the most useful information regarding the offenders is typically the probation office or the court administrator rather than the assigned attorney. Members, this has been supported by, or is supported by the courts and the County Attorney Association, and I know of no known opposition. Thank you.
There are no amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File 2386.
Third reading. Any discussion? Seeing none, the clerk will take the roll on the bill. The clerk will close the roll. There being 120 ayes and 0 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is House File 2949. The clerk will report the bill.
House File 2949, the first engrossment, an act relating to unemployment insurance.
The member from Beltrami, Representative Persell.
Thank you, Madam Speaker. And in a side meeting here, I apologize. House File 2949. Make sure we're doing the House File. We're doing the, yeah. 2949 is a bill that deals with Unemployment Insurance Advisory Council's policy and housekeeping for 2014. This advisory council is an informal group. Participants include the AFL-CIO, Chamber of Commerce, Legal Aid, Federation of Independent Businesses, Minnesota Mechanical Contractors, legislators, including our own Representative Mahoney, O'Neill, and Gunther. And the provisions of this bill do a few things here. I'm trying to turn my page. Provisions in this bill are going to clarify how severance pay affects unemployment insurance eligibility. We're going to lower interest rate that employers pay on their debts to the unemployment insurance system from 18 to 12%. Going to lower the interest rate on debt owed by workers to 12%. This brings it in line with what most states are doing in both those areas. Makes it a little bit easier for everybody to get back on their feet if they've had some troubles with that particular part of the unemployment insurance system. There's record keeping requirements are modified. Severance agreements. If a worker and employer agree on severance payment, for instance, in August, the eligibility period starts in August, then even if the check isn't cut till November. So that's giving you some examples of things that we're doing with this bill. And I see there aren't any amendments, so I'm gonna leave it there at this point. Dig out a little more information, Madam Speaker, and stand for questions at this point.
There are no amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File 2949.
Third reading. Discussion. Seeing no discussion, the clerk will take the roll on the bill. The clerk will close the roll. There being 120 ayes and 0 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is House File 263. The clerk will report the bill.
House File 263, the first engrossment an act relating to public safety.
The member from Ramsey, Representative Paymar.
Thank you, Madam Speaker. Members, this bill adds the following offenses to the definition of crimes of violence: felony conviction for fifth-degree assault, domestic assault, and domestic assault by strangulation. I might add that these are felonies, and you should be getting a letter from the County Attorneys Association that outlines what this bill does and why this is a priority for them. I agreed to carry it for them. And just again, if you look down on the second paragraph, when it talks about that the bill would only apply to truly serious perpetrators of domestic violence. Convictions of felony-level domestic assaults and fifth-degree assaults occur only when a perpetrator has committed 3 or more separate domestic violence offenses within 10 years. So this has been a bill that the county attorneys have wanted over the years, and we haven't been able to fund it, quite frankly. So what we did is that we removed several nonviolent crimes, which include auto theft, theft from a burning or abandoned or vacant building, and third-degree burglary from the crimes of violence statute. And now we don't have a fiscal note. The bill is revenue neutral. So that's the bill, members. I'd be happy to stand for questions. Appreciate your support.
There are no amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File 263.
Third reading. Discussion. The member from Sibley, Representative Grunhagen.
Oh, thank you, Madam Speaker and members. I'd just like to thank Representative Paymar for bringing this bill forward. I was an author on this bill when we were in charge a couple years ago. And I have to share one interesting story about this. When Representative Simon and I were at the University of Minnesota Law School on a panel debating the marriage amendment at that time, there was probably about 200 or so law students and some attorneys in the audience. And after our debate, I had an elderly lady come up, and I can't remember if she was an assistant city or county attorney for the Minneapolis area. But she identified herself as being DFL, but she wanted to thank me for authoring this bill. And these are her words, and I quote her. She said, "If this bill passes, I will die a happy woman." Okay? So you're making somebody happy here today. And I do believe, members, that increasing the consequences for this type of behavior is the effective way of reducing violence against women and children. You know, I voted against that gun bill we had here a few days ago because I believe that didn't really take the right approach, and this does. If you want to reduce criminal behavior, you need to raise the consequences. I'll just give one more example. When I was first here, we had, I was serving on public safety, we had a police dog that had been injured by a criminal and had been paralyzed in its back legs. And we had a bill, okay, to raise the consequences to people who injured animals. And so the fact is that becomes a much more effective way of dealing with negative behavior rather than trying to address whether or not they have a particular weapon. So, members, I think this is a strong step in the right direction for the protection of women and children. And also, the other thing we could do down the road is expose the lies of Dr. Alfred Kinsey and his fraudulent research. And just as a footnote, but maybe Representative Paymar, you and I could work on that next, or you're not coming back, that's right. And I know you probably didn't agree with everything I just said, but I do support your bill 150%. Thanks you, Representative Paymar.
Any further discussion to the bill? The member from Hennepin, Representative Hertas.
Thank you, Madam Speaker. If the author would yield for just a clarification.
He will yield. Representative Hertas.
Thank you. Representative Paymar, in the text of the bill, I just was curious, this is 3 or more separate domestic violence offenses, not necessarily against the same individual, or just 3 violent acts against cumulative any individual? Could you answer that for me, please?
Representative Paymar.
Madam Speaker, I believe it is the same person. I could clarify that for you. I remember when this crimes of violence statute was enacted and amended.
Go ahead.
It's It's the same person, the victim, if it's been committed within 10 years, 3 offenses, and for different victims, it's 3 and 3 years. If that makes sense. That's what staff is telling me.
Representative Hertas.
Well, very good. Thank you for that clarification, and I'm happy to hear that because consistent with the comments that my colleague, Representative Gruenhagen, just made, I believe it's important to penalize the behavior, and I was hoping that it would include other persons and not cumulatively just against one person. So thank you very much.
Representative Paymar.
Madam Speaker, then members, I would urge a green vote for the Paymar-Gruenhagen bill.
Seeing no further discussion, the clerk will take the roll. The clerk will close the roll. There being 120 ayes and 0 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is Senate File 2718. The clerk will report the bill.
Senate File 2718, the second engrossment, an act relating to the judiciary.
Member from Hennepin, Representative Hilstrom.
Thank you, Madam Speaker and members. Members, this bill takes the 90-day rule that requires judges to produce their opinions within 90 days, and it takes it from the Judicial Standards Board for review, and it actually gives it to the Chief Judge of the Judicial District. Right now, if a judge misses that 90-day deadline, it actually becomes an ethics violation. And we think that this can best be managed by the chief judges in the districts to make sure that judges are actually complying with the rules rather than having this taken on after through an investigation through an ethics complaint. That's the bill, Madam Speaker, and I encourage members to support it.
There are no amendments at the desk. The clerk will give the bill its third reading.
Third reading, Senate File 2718.
Third reading. Discussion. Seeing no discussion, the clerk will take the roll on the bill. The clerk will close the roll. There being 120 ayes and 0 nays, the bill is passed and its title agreed to. Reports from the Committee on Rules and Legislative Administration.
Report from the Committee on Rules and Legislative Administration. Murphy E. for the Committee on Rules, pursuant to Rule 121 and 333, designates the following bills to be placed on the calendar for the day for Tuesday, May 6, 2014. Senate Files 2490, House File numbers 2950 and 2467, Senate File numbers 2609 and 2642, House File numbers 2255, 2881, 2602, and 1915, and Senate File Number 1340.
Motions and resolutions. There are copies of the non-controversial motions at the House desk and online. If there is no objection, we will take action on those motions first. Hearing no objection, the motions prevail.
Hansen moves that House File 2622 be taken from the table.
Representative Hansen.
Thank you, Madam Speaker and members. House File 2622 is the bill that we tabled a couple of days ago. I'm asking that it be, I move to take it from the table.
No discussion. All those in favor of the motion, please say aye. Aye. Those opposed, please say no. The motion prevails. The bill is taken from the table. Discussion. The clerk will report the bill.
House File 2622, an act relating to clean water. It's the first engrossment.
Representative Hansen.
Thank you, Madam Speaker. And this is the bill we were debating a couple days ago. There was some questions and concerns about the bill. Since that time, and I think you should be getting two letters handed out, one from the League of Cities, Townships, and Lake Associations, the other from the Minnesota Pollution Control Agency and the Public Facilities Authority. We did meet with some members who were interested in this, and I believe clarified that there has been no use of this provision.
Representative Doubt.
Thank you, Madam Speaker, and Representative Hansen. Most of all, I want to thank you for allowing us the opportunity to table the bill the other day to have that further discussion. I think that was important, and I know there were some questions that came up on the floor. I think since then, I think everybody's gotten satisfactory answers to those questions. I am still, unfortunately, going to vote against the bill, but I really do appreciate the work that you did. And the reason I'm going to vote against the bill, I think this is a bill that removes something from statute that hasn't been used, but unfortunately, and there really hasn't been a problem on either side of it. There hasn't been a problem with the use of this language, and there hasn't been a problem by if we would take this language away, there hasn't been a problem yet. But what I'm worried about is that in the future we may be limiting options. I didn't want to limit that ability for municipalities or for townships or anybody else to exercise this if it was something they wanted to do. So I'm going to vote against it. But I really did want to sincerely thank you for tabling the bill and letting us have an opportunity to vet this a little further. So thank you, Madam Speaker and Representative Hansen.
The member from Roseau, Representative Fabian.
Thank you, Madam Speaker. And to Representative Hansen, obviously we had some concerns about this earlier in the week, and you were kind enough to lay the bill on the table so that we could get some clarifications as to the potential that may exist. We found out that there's really no harm to any existing facilities that are in place. There were some concerns about some sanitary districts in my district and Representative Erickson's district and so forth. We were assured by a variety of representatives from rural Minnesota through the townships, the league and so forth, that this does not have any immediate impact. The one point that I do want to make, in spite of the fact that Representative Holberg has mentioned that this is Friday and that some people are anxious to get home, maybe in a little bit stronger terms than that, but I have the furthest to drive of everyone, so I get a little liberty. I am concerned that, as I expressed to you earlier in conversation, that it would have been, for me, more palatable in the bill if we had actually taken the language that was there and created some sort of a pathway for the potential for innovation into the future with regards to the language that is being changed. And that would have given me a little bit more comfort. I am willing to support the bill today, and thank you for your willingness to work with us. Thank you, Madam Speaker.
The member from Lake of the Woods, Representative Erickson.
Thank you, and Madam Speaker and Representative Fabian. We talked. I was at that meeting. All our concerns were laid to rest. I think it's a good bill to take out and start over if something like this needs to happen in the future. So thank you, Representative Hansen. Thank you, Madam Chair.
Representative Doubt.
Thank you, Madam Speaker. Representative Hansen, I've got good news. Representative O'Driscoll just convinced me to vote for it. So,
any further discussion? Seeing none, the clerk will take the roll on the bill. The clerk will close the roll. There being 101 ayes and 19 nays, the bill is passed and its title agreed to. Announcements. Representative Murphy.
Well, thank you, Madam Speaker. I move that when the House adjourns today, it adjourns until 11 a.m., Monday, May 5th, 2014.
Representative Murphy moves that when the House adjourns today, it adjourn until 11 a.m., Monday, May 5th, 2014. All those in favor, please say aye. Aye. Those opposed, please say no. The motion prevails. Representative Murphy.
I move that the House do now adjourn.
Representative Murphy moves that the House do now adjourn. All those in favor, please say aye. Those opposed, please say no. The motion prevails. The House stands adjourned until 11 a.m. Monday, May 5th, 2014.